First argument is People versus Johnny Ray Kennedy.
Good afternoon. Erin Van Kampen of the State Appellate Defender Office, appearing on behalf of Johnny Ray Kennedy. With me is co-counsel Jacqueline McCann. If I have any time remaining, I would reserve that for rebuttal, no more than 5 minutes, and I will keep track of my own time. This court should use this case to clarify that a statute cannot displace or diminish a constitutional right. This is necessary because our state courts have a regular practice of misapplying a compulsory process statute, MCL 775.15, to review indigent defendants' requests for expert assistance. They have applied this statute in lieu of the constitutional framework explained by the U.S. Supreme Court in Ake v. Oklahoma. This practice has been problematic for 3 reasons. First, the statute only provides for expert assistance in the form of testimony at trial, when the Constitution entitles defendants to much more, including the assistance of an expert to evaluate the evidence, to prepare a defense, and to plan the presentation at trial, including preparing counsel to ask those probing questions that matter most during cross-examination. Second, the way this statute has been applied has required defendants to make a greater showing than is permitted under the Constitution. Finally, by supplanting a constitutional analysis with a statutory one, defendants also face a higher burden on appeal, even when they preserve this claim on constitutional grounds. This court should issue an opinion that clarifies the defendant's request for expert assistance must be reviewed using the constitutional analysis. And this court should grant a new trial, because the prosecution cannot prove beyond a reasonable doubt that this preserved constitutional error was harmless, even with the additional facts that were provided to the court last week. At minimum, this court should find error and remand for an evidentiary hearing on harm. I'm happy to answer.
Yeah, well, you just led me right to where I wanted to go. Thank you, counsel. If we determine that, if we agree with you that the Constitution applies here in this area, and we determine that the defendant made the threshold showing needed to get funding for, in this case, a DNA expert, what is the remedy? I mean, is it sufficient for him to get a new trial here and now, or should we send it back to the trial court so that he can get the funding, consult with an expert, and then show the trial court why it would have made a difference?
Well, the second remedy you suggest would be incorrect here, because it's the state's burden here, not Mr. Kennedy's burden, to prove that this error was harmless beyond a reasonable doubt. And that's because it was a preserved constitutional error. Now, our position is that on this record, this court should grant a new trial. The harm cannot be proven beyond, or the harmlessness cannot be proven beyond a reasonable doubt, because counsel, first of all, did pay out of pocket for some of the expert assistance he sought, but he did not get it all. And that was borne out at trial, where he struggled through cross-examination. He struggled to ask those probing questions. He conflated the run-of-the-mill DNA testing with the highly controversial STR mixture testing. He asked, using cross-examination, to ask the experts to re-explain terminology to him, to re-explain things that the prosecution had drawn out that only supported the prosecution's case. And then he struggled to impeach the witness using some of the materials that the expert did help him to become aware of. And he wasn't prepared to call a witness to impeach by contradiction if he had to.
It's just a weird, it's hard for me to imagine how this harmlessness hearing goes, because, so we remand, I mean, not just in your case, we determine there's an Ake error in any given case, and we remand for a harmlessness hearing, and it's the prosecutor's burden. I understand how that works, but the prosecutor then puts on, I assume, an expert like the one they called at trial, who would say no expert on the other side would have made a difference in the outcome, and then of course you're going to have to, I assume, put on some expert to rebut that. and your expert would say it would make a difference in the outcome. I'm struggling with what the harmlessness hearing looks like.
Well, and I think part of the problem with this idea of the harmlessness hearing, and this court has, in our brief, I believe we mentioned the Webb case, the prosecutors mentioned Agar, has a couple of times done this, but the orders sort of suggest the defendant must put on an expert who would say the testing done by the state's experts was wrong. If that is the only form of harm this court is recognizing, that falls short of AIC and the Constitution, because what our courts are sort of lacking, and I think it's because of this misapplication of this compulsory process statute out of context, is any appreciation for the critical role that experts play in preparing counsel to do these effective cross-examinations, something that this court recognized recently in People v. Ackley, that the expert's role is more than just perhaps putting on testimony, but arming counsel to effectively cross-examine. And so the orders of this court in combination, I think, with the regular practice, leave our state courts undervaluing that critical role.
How do we know that what was made available in the circumstances of this case was in fact not adequate, apart from the fact that you suggest that counsel didn't do an extraordinarily impressive job at trial?
Well, that is the easiest gauge to measure.
Well, we don't know. There's all kinds of reasons why one wouldn't do a good job, some of which have nothing to do with the assistance that was available to him, right?
Well, Your Honor, we've pointed out a number of problems that did have to do with the assistance or lack thereof, specifically him conflating the key types of DNA analysis involved in this test, his failure to impeach this witness with available materials. But also, I mean, the real critical part of the analysis is the centrality of that evidence in the state's case. That materiality piece is both a very important component of the test trial court should be applying to determine if the expert assistance is required, but also is an important part of the harmless error analysis. And here, the prosecutor told the jury the wonders of science had proven that Mr. Kennedy killed this woman, that DNA showed he did it, emphasizing the mixture DNA analysis under Mr. Kennedy's fingernail, because that was, in her mind, what took this beyond, you know, the consensual sex that Mr.
I'm just trying to understand the constitutional violation to the extent that it arises at the time, does it not, that expert assistance is requested by the defendant and it's not given? It doesn't manifest itself in the first instance when defense counsel does a poor job cross-examining a witness, for example, during trial. Is that right?
That's true. That's true. And the record also bears that out to a certain degree, specifically related to the stipulations. Attached to those stipulations, we've stipulated also to the court's consideration of Mr. Zubel's fee motion. And it's clear from that he was consulting with Mr. Zubel not just about perhaps the hard science, but even just knowing what he needed to get in discovery so that Mr. Zubel could provide the assistance that trial counsel sought. And so it's a situation where the expert was not just critical to his ability to cross-examine. So Your Honor is absolutely correct. It was also critical to his ability to even get all the discovery in the first place.
If the standard is AIC, do you see what role does this statute play in expert witness? What is the proper role for this statute?
I don't think the statute has a role to play when it comes to the appointment of experts under AIC. It wasn't intended for that purpose. We've laid that all out in our brief. It's sort of been misapplied in this context. And it wouldn't surprise me if it's because trial attorneys were looking for any way the court might feel authorized to give them funds. But I think perhaps if the court is concerned about that continuing to be an issue, a court rule codifying AIC and clarifying the appropriate analysis trial courts should apply might make sense.
So is there any limit at all to how much the court has to provide to counsel in preparation to understand this DNA evidence? I mean, somebody who's never tried a case at all, right out of law school, just licensed, are they entitled to unlimited access to experts, or is there some limit?
No, not at all, Your Honor. The balancing test elaborated on in AIC actually does set these limits. The expert assistance sought has to be material. It has to be relevant to the case the prosecution is presenting as far as defense counsel knows. And if it's not, the defense doesn't get the assistance. It also has to, the defense does have to make some showing that the assistance is likely to be helpful. Here, trial counsel made a very clear showing of why he needed this expert. He was faced with a number of conclusory and highly technical lab reports that he did not understand. He was in exactly the situation that Mr. Ackley's attorney was in, except instead of doing what Mr. Ackley's attorney did, this attorney did take the extraordinary step of paying out of pocket to get some assistance, some of the assistance he sought. And I think, if anything, that just shows how critical he felt his understanding of this was to his ability to try to perform effectively at trial.
I'd like to follow up on Justice Wilder's question. Are you saying that whether or not a constitutional violation arises in this context is at least in part a function of the expertise and the experience of the lawyer? The less expertise, the less experience, the more the lawyer's fresh out of law school, the more the Constitution requires in terms of assistance requested by that lawyer.
I don't know that I would agree with that statement as Your Honor has formed it.
It's not an assertion.
Well, I think it depends. It is, yes, I understand it was a question. I don't think I quite agree with that. I think it depends on how courts are assigning counsel to cases, right? So if a court is regularly assigning attorneys fresh out of law school to first-degree murder cases involving a lot of DNA, then yeah, there might be a higher need for expert assistance for those attorneys.
But would that be an AIC problem, or would that be a constitutional violation predicated upon some other element of ineffective assistance of counsel?
I think it would depend a bit on how the county is assigning counsel and things like that, and the requirements to serve as counsel, how exactly I would frame that issue as an appellate lawyer. But I don't think that the right in AIC necessarily depends on an attorney not having prior experience with DNA. For this attorney made a very clear showing of why this expert had knowledge that he himself could not acquire alone, that was necessary for him to litigate this case, separate and apart from his...
And then he got some assistance, arguably inadequate assistance, but he got some assistance. How do we know that what he got in the form of assistance was constitutionally sufficient or not?
Well, first and foremost, I would say that the fact that he himself paid for some assistance does not exonerate the trial court's error in denying that assistance in the first place.
It's got to be a factor, though, doesn't it?
I'm sorry?
It has to be relevant. If you get the assistance by whatever means, you need less assistance, presumably, in order to bring yourself up to constitutionally minimum standards, don't you?
I would agree that it relates to the harm component, but it doesn't...
We're trying to figure out the next 100 cases, not just your case. How is it that we decide? How is it that we define this constitutional right, and how is it that we decide that it's been satisfied by a particular process such as existed here?
For example, if counsel spent $3,000 and went to a couple of seminars and learned this area of the law and doesn't need to ask the court, that's what we're trying to figure out. Where's the line? Where does the court have to provide the assistance under the Constitution, and where is it on the lawyer to come up to speed on what the lawyer needs to know?
So I have 2 points I want to make in response to your questions. First, I don't think this is a situation that is very amenable to a super bright line rule. I think that's exactly why the Matthews v. Eldridge test is what was applied by the U.S. Supreme Court in AIC. It is hard to come up with a clear line that will apply to the next 100 cases down the road. And so the balancing test is, I think, the answer to that. And we trust trial courts to administer balancing tests of all kinds all the time, but they need to have the right framework to know what they're balancing. And right now they don't because of the misapplication of this statute. The other thing I would just say is that we are not working in a vacuum here. The majority of states apply the Matthews v. Eldridge due process balancing test in this context. And our own Court of Appeals applies that very same test in the family law arena. There was a decision in the very beginning of last year in Ray Yarbrough, which I did not cite in my brief, so that's at 314 Mishap 111, where they adopted exactly this test for parents facing termination who need expert assistance in order to comport with their due process rights in those proceedings. So this isn't reinventing the wheel. The court does not need to do that.
Well, how do we know AIC even applies in this context?
Well, for a couple of reasons. First, the vast majority of courts that have considered that question have concluded that AIC applies both outside of the death penalty context and beyond psychiatric experts. The most recent compilation I've been able to find on those cases is in State v. Wang, cited by the prosecutor in footnotes 14 and 15. And even if the court decided to, I guess, not go with the majority consensus of the states on that front, the court would still have to analyze this under our state's due process standard and should reach the same result for the same reasons articulated by those courts, which is that the justifications, the legal basis for the right recognized in AIC apply with equal force to other kinds of science, if not more so when it comes to some of these forensic sciences that have been well established to be both fallible and subject to overstatement.
Okay. Well, thank you, counsel.
Thank you.
That was me. Sorry.
Did you have some questions?
No, I just was messing up with my microphone.
May it please the Court, Anna Quiros on behalf of the people. AIC held that in order to determine whether an indigent defendant is entitled to an expert, the court must consider the probable value of the expert's testimony and the risk of error in proceeding without the assistance of the expert. While the courts have expanded experts beyond insanity cases, no case has ever held in the federal court or in Michigan that an expert should be appointed on demand or without a showing of need. 775.15 and Tanner are consistent with AIC. The statute requires that the defendant show that the witness is material and favorable, and in this court, Tanner decision decided that the defendant is required to show a nexus between the facts of the case and the need for an expert. Therefore, when you consider the AIC case, Caldwell, Tanner, and to borrow from Professor Lefebvre, the defendant has shown that he's entitled to an expert only when he can demonstrate to the trial court both that an expert will challenge an issue that is critical to the prosecution and some factual basis to believe that the expert assistance is needed to strongly contest that issue. Here, defense counsel's statement that DNA is complicated was nothing more than what Caldwell called an undeveloped assertion. Therefore, the judge's denial of his request for a DNA litigation expert did not violate due process and the judge did not abuse his discretion. Even if this court finds the defendant demonstrated that the trial court erred, defense counsel or defendant cannot show prejudice because, in fact, defense counsel did hire and consult with the DNA litigation expert that he wanted. The people would just ask that the court deny the defendant's application. So
is your view that the fact that the defense counsel paid out of his pocket to get some assistance, that we can therefore find that in this case, if there was error, it was harmless? Is that your
Yes, I believe you
view
can.
of what the
I believe you can, because that's what he was asking for. And if you found
paid for it himself, good enough?
Well, as you know from what we did file, he did get extraordinary fees in the amount of $9,400 a year later. And part of the list of things that he put out in that motion was all his consultations with Mr. Zubel.
It was more than consultations, wasn't it? It was studying the DNA treatises and things of the like to prepare for cross-examination. I think it was 17 and a half hours of preparation for cross-examination.
So in this case, Mr. Haller, the defense attorney, did exactly what an attorney should do. He studied up on what he had to study up to represent his client effectively, and which is very different than the Ackley case that counsel brought up, where this court specifically stated the trial attorney in that case did the exact opposite. He didn't pick up a treatise, he didn't consult, and his problem was he could not handle the case. He was ineffective because he was not prepared. That is not what happened here. Mr. Haller educated himself, whether he paid out of pocket, if that was the course he wanted to take to educate himself versus, and I think he did buy Mr. Zubel's book, but he did what the judge told him to do, prepare, and he did. Now, if he had come back to the judge at a later time and said, I cannot handle this case, then we have a different situation. He didn't. He did exactly what the judge told him that a good attorney should do, and he represented his client. I've looked at the transcript. There is nothing that's shown that he was ineffective. There's an actual strategy to all of his questions, and he brings out...
Well, Counsel, good morning. I just have a question. Your statement, there was nothing that's shown that he was ineffective. You don't feel that it was a little bit of a disadvantage that it appeared that he was learning about the scientific evidence the same way the jury was in terms of his line and discussions that were taking place in the court? You don't feel that it appeared as though, you know, for the transcript, that he was learning about the science while the trial was taking place?
Oh, not at all, Justice. Not at all, because
he was asking, it seemed to me, that when he'd ask questions, he wasn't asking questions that he knew the answers to. He was asking questions because he actually needed information.
Well, there's, with all due respect, there's really no basis to believe that, because we know what he did in preparation for the trial.
I'm talking about what he...
Right, and I'm going to refer to the transcript itself. What he did, as you know, because you have read many, many transcripts, the prosecutor's task when showing science is to make it as simple, easy to understand as possible. The defense attorney's role is to attack the simplicity of that display.
But he wasn't attacking; he was learning. It appeared like it wouldn't be fair to. So you just because it appeared that it seemed to me as though he was actually going through a learning function, which gave a higher degree of credibility to the prosecution, because it appeared as though the defendant was learning about this evidence rather than disputing the evidence.
That's not the way I read it. The way I read it was him bringing up terms that the prosecutor had not brought up, him bringing up issues of possible contamination that the prosecutor didn't bring up. He brought up complicated terms. He understood the process. He targeted different areas where there could be contamination or there could be problems. Because what he's trying to do, which he argued at the end in his closing argument, was you can't trust the science. And maybe for some jurors, that would have helped.
Hypothetically, counsel, let's say he hadn't put down his own $1,000 or money to go and do this. What would change? Let's say he didn't put in his own money to get this expert. Would your perspective change if he had kind of gone forward without having done that?
I think that when you see the list of things that he did, perhaps he wouldn't even have needed that, because there's nothing to show that something else would have changed his questions. Nothing has been suggested that there's something that an hour more consultation or another treatise would have helped in cross-examination of representing this client.
Aren't we kind of confusing the ineffective assistance standard with this AIC due process standard? One is kind of an output standard. How good a job did the counsel do at trial? It seems to me the issue that we're dealing with here is kind of an input standard. You know, what is it that's necessary as a threshold matter to ensure that some preliminary expertise is given to an attorney and a defendant who requires that?
Well, I think what the court has to decide is, what did the judge err? The point of error that we're looking at is, what did the judge do when he was confronted with Mr. Holler's request for a litigation expert, so a DNA litigation expert. And there's nothing to show that at that point there was anything more that he could have said or that would have given him the right to an expert. In that case, because he's asking for an expert, if the judge abuses his discretion, it's a due process issue.
Well, I guess I'd like to ask you the same question I asked your fellow counsel there. How is it that we know that the assistance that was provided here was or was not constitutionally sufficient? It's assistance designed to assist in the evaluation, preparation, and presentation of the defense. Defendant got $1,000 worth of assistance. I think essentially the defendant is arguing they needed $2,000 worth of assistance, and you're saying no, $1,000 was enough. I mean, how are we supposed to assess this?
I don't. I think that you're right when you say there's a mixture between what the judge's error, whether there was a judge error or whether there was an ineffective assistance of counsel. If you have like the Akey case where the defense attorney, it's not a violation of his due process rights because of the judge's decision whether to grant him an expert. It was whether the defendant was ineffective in representing the client after he was given an expert. So I think that there has to be some kind of showing that there is something that the defense attorney could have said to the judge at that point when the judge made the decision, and there simply hasn't been such a showing.
You agree that if we find there is a constitutional right to some measure of expert assistance outside the context of psychiatric testimony, so maybe including in DNA cases, that's a preserved constitutional claim in this case, right?
Yes, I believe so.
And so if there was a preserved constitutional error, you would agree that it would be your burden to show beyond a reasonable doubt that it didn't harm the defendant, right?
Yes, and as you did in Agar, it would be remanded for the trial court to make that
But Agar
determination.
might have gotten the burden wrong there, right? If it's a preserved constitutional error, it's your burden to show that you don't think this is different from any other preserved constitutional error. It's your burden to show that there was no harm, right?
If the court found that it was a due process violation as opposed to an abuse of discretion.
Right, I said a preserved constitutional
Right.
error. You're with me, right?
Yes.
Okay, so preserved constitutional error, you have a burden to show it wasn't harmful, right? Why do we need to figure that out? Why don't we send that? It sounds to me like there was some measure of assistance given, and probably there's going to be differences of opinions about whether it was enough. Why is that the job for us? Why isn't that something you might want to put more evidence on in a trial court and the other side might want
Well,
to?
before we get there, you have to decide whether the trial court
I understand what we have to do to get there. I was just asking about
Right.
the question that you were talking to the
Right.
Chief Justice about.
But because there was no error by the trial judge, there's nothing to correct here. There's nothing to remand.
That's not really engaging my question. I'm saying just go with me for a minute and assume we think the Constitution applies and we think, therefore, there's preserved constitutional error. Then
Okay.
what do we do about figuring out whether it made a difference in the outcome? Why should we sort that out? Why not send it back
Oh,
for
no,
a
that
hearing
is,
on harmlessness?
I agree.
Oh, okay, good.
I agree. I'm sorry. I
Okay.
agree. I agree that it would go back for a remand for the trial court to decide that.
Okay.
I understood that you also agreed with fellow counsel in terms of the proposition that there needs to be a better test in Michigan than the Tanner test. You seem to agree with fellow counsel that some element of the AICI 11th Circuit / Moore test needs to be required in Michigan. Am I interpreting you correctly when you say when I
Well,
say that?
I actually thought that counsel, that the appellant's position was that if you're indigent and there's science that's relevant and the scientific evidence is contested, then you automatically get an expert. And that's what they put in their brief. My position is that there is nothing there's nothing that's inconsistent with due process in the statute or in Tanner. So you don't need to do anything to abide by the Constitution or the statute in this case. All you have to do, you can deny the defendant's application, and there is no other rule has to be established in this case.
I thought the concern with the Tanner test, particularly its third prong, was that it was kind of a catch-22 standard in terms of imposing upon the defendant the obligation to show that the expert assistance would likely benefit the defense at a time when the defendant just doesn't have enough understanding, arguably, to know what would benefit the defense.
If that is the point they're trying to make, and I would just cite People v. Kemp, which I know that the dissent in this case talked about how unfair it is to have a defense attorney make a factual basis to the judge in order to get an expert. And in Moore v. Kemp, the court said that we recognize the defense attorney might not be familiar with specific science, but the defense counsel is obligated to inform himself about the scientific evidence in question and provide the court with such information as possible concerning the usefulness of an expert. There's nothing that is unfair or unconstitutional about asking a defense attorney to educate himself enough to present the court with something more than mere speculation. And this is what we have here.
Do you have a question?
No.
your case was really very focused on the scientific testimony, correct?
Yes.
Okay. So I just want to ask this question because I think that this case goes really a tremendous distance and is going to have some profound implications. And I guess my question to you is, and I'm just going to ask it, do you think that's fair? Do you think that that's equitable if you have a case where you have scientific evidence, you have the government? Let me ask you a question. What resources do you have as the government when you're putting on a case of scientific evidence? Do you have any limitations as to the resources you're able to put to bear?
Yes, we do.
What are your resources? You have a police
We have
department?
the MSP, we have the police department that's investigating the case, and scientific evidence, we have the
Crime
state
lab.
police. Right.
You can, but let's look at what you can avail yourself of. You can avail yourself of an entire police force, correct?
Correct.
You can avail yourself of a crime lab, correct?
Yes.
You can avail yourself of even the federal officials if you need to. You basically, you have the resources of an entire government at your disposal, do you not?
I wouldn't go as far as to say that.
But you have governmental
But we do
resources.
have the burden of proof.
Okay.
And the question before this court is not, is it fair? The question is, was defendant denied his constitutional right?
I understand, but that's what I wanted to ask you though, because sometimes you kind of have to look a little beyond this, and you have to look at this. Isn't the job, and I've been thinking about this case, for quite a long time. Isn't the job of the government or a prosecutor is your job to get a conviction, or is your job to find truth?
Our job is to enforce the law and to present the evidence. It's
see.
not to get a conviction.
I understand, but is there an element of your job that's dedicated to finding truth? In terms of you represent the government, you represent the people. So isn't a portion of your job to ultimately find the truth that is the truth, what happened? Isn't the truth a component of what you're supposed to do?
Yes, but I'm trying to understand how that goes to the facts of this case.
Because the facts of this case are, and this is what I'm trying to gather, and I'm trying to understand kind of your position, I'm trying to understand the equitableness in this, is that you have a case where you have unlimited resources when you're dealing with scientific evidence like DNA. Highly complicated, highly scientific. You've got pretty much a variety of resources that are pretty much at your disposal. And I guess my question to you that I just am thinking about is, do you feel, we're talking about constitutionality, but we're also talking about the sense of what is right. Do you feel that it's appropriate and that you feel it's just and you feel it's right that in this situation, an attorney who is trying to present a case where he's going up against all these resources shouldn't be permitted to have an expert witness to at least help educate him to understand the evidence that he's trying to contend with?
I think that if Mr. Haller had gone to the court and said, I don't understand this, as what happened in the McWilliams case, I can't read this, I don't understand this, the science is over my head. When there was neurological evidence in the McWilliams, the United States Supreme Court case, I think that you have a situation where that he has established a need for assistance.
Okay, so then your position would be, just so I understand kind of how we can move forward on writing an opinion on this or looking at how to address this, your opinion would be then, if an attorney then went to the court and said, Your Honor, I can't do this. I don't know this evidence. I don't understand this evidence. I don't appreciate this evidence. If the attorney were to put forth an argument saying, I do not have the level of understanding that the government currently does, then the court would be required to then provide
If he's
this
asking for an
assistance?
expert. Yes, and I think that in the Ackley case, the defense attorney did nothing.
Okay,
Did nothing.
but
So
my question is, if I'm writing an opinion and I'm looking for a trigger point, would a trigger point be activated if the attorney goes forward and says that as a script and says, Your Honor, I don't have the necessary information or knowledge to proceed on this case. I am in desperate need of an expert in order to. If an attorney does that and has a script for it, would it then be your position that the expert would then have to be required at the government's expense?
I think that at that point he's meeting the statute. The statute says that the defendant cannot proceed safely without a witness. And in that case, he's met the statute.
Okay, so is there specific language or specific things that an attorney could use then from your argument to basically, as they're going forth, to guarantee an expert witness at the government expense?
That the expert is, the witness is material and favorable, and the defendant cannot proceed safely to trial without
Okay,
the
so is it
witness.
your position
Yes.
then that once an attorney does that, that they are automatically entitled to then have the expert that they seek?
Well, it's the
Or they
judge's
would require?
discretion. It's the judge's discretion.
What
to
if the
find-
judge doesn't, what if the judge, if they do what you just said and the judge turns it down, then what?
Well, then you appeal it. You appeal it like you would in any other case, and you determine whether the judge abuses discretion.
Okay.
There can be an appeal before you go to trial.
Thank you, counsel.
Thank you, Counsel.
Thank
Your
you.
time is up. Ms. Benkamp, and I think your time is up as well. The case is submitted. Thank you.